Welcome, everybody. Glad you could join us to this afternoon's session, Demystifying the Claims Journey. I'm Tony Corletto, the Chief Legal Officer here at HAI Group. I'm pleased to be joined today by two esteemed colleagues, Dr. Reginald Freeman, our Chief Risk Officer, and Mr. Pat Troiano, our Director of Claims. Reggie's going to take us through risk management and claim avoidance. Then Pat will take us through the claims process A through Z. And then I'll give us a conversation about litigation trends, things that affect liability claims. At the end, we'll have a little time for question and answer. Before we begin, I want to give a special shout out to Jeff Wade from the Cuyahoga Metropolitan Housing Authority. This session was sparked by a suggestion from him. So thank you, Jeff. And I think with that, we're ready to start. Reggie, are you good to go?
I am good to go. Thank you so much, Tony. And good afternoon, everyone. As Tony mentioned, I am Reggie Freeman. I am honored to serve as a Chief Risk Officer for HAI Group and serve our risk control consultants who work extremely hard on your behalf to make a difference. And today, I have the honor and the privilege to briefly speak about risk management strategies to avoid claims. And I'm joined here, of course, with our Chief Legal Officer, Tony, and then our Director of Claims, Mr. Pat. So we have a lot to get into in 15 minutes, so let's jump right into it. Next slide. So with risk management, there are 5 key components, and we're going to talk about these key components. Now, obviously, we're not going to be able to cross every single T and dot every single I in 15 minutes, but please call me directly if you have any questions or email me if you'd like to talk more about risk and risk management, because obviously that's all I think about day and night. But getting right into it with the first component of risk management, risk identification. Next slide. So as you can see, go ahead and go through these sets, Andrew. Thank you. As you can see, there are so many different elements as we look at risk identification. So I just want to pull out a few of them that are very critical that you and your team should ensure that you focus on. First being the stakeholder involvement. So with stakeholder involvement, it's exactly what it sounds like. You want to ensure that any person, whether it be within your organization or outside of your organization, that has some sort of input or feedback to be able to contribute to ensure that your site, your personnel are as safe and secure as possible, that they are afforded the opportunity to be able to provide that information. So diverse perspectives are a good thing. Different stakeholders, they may perceive and understand risk totally differently. And of course, their input is invaluable for the comprehension of risk identification. There are certain things that they can see from their level that you may not be able to see from yours. So it doesn't matter if someone's been a member of the team for 5 months or 15 years. Everyone has something to contribute to make a difference. Historical data and lessons learned. You know, the greatest indicator of what's going to happen in the future is what's already happened before in the past. And so not only should we look at those things that have happened, and maybe some of those incidents rose to the level of you having to file a claim, we should also look at near misses. That's something that we tend to oftentimes forget about. Just because it didn't rise to the level of a claim, we tend to wipe our eyebrow and breathe a sigh of relief and go on about our day, when we should really study and break down exactly what happened and what we can do in the future to prevent that from occurring. Because even though it didn't rise to the level of filing a claim this time, if it happens again in the future, it just might. So just keep that in mind. Risk categories. So common categories include technical, financial, environmental, regulatory, and reputational risk. So when you are going through your risk identification process, you want to make sure that you have those common categories in queue. Categorization, it helps in organizing and prioritizing the risk for effective management. So ensure that you and your team, you do that. Next, risk events and causes. So this, you identify both potential risk events, the what could happen, and their underlying causes, which is why they could happen. So understanding the root causes helps in developing proactive risk mitigation strategies. Next slide, please. So taking a look at risk analysis, and I know there's a lot on this honeycomb infographic. Tony told me not to use it, but I'm slightly hard-headed. I use it anyway because I like all the colors. So let's take a look at risk assessment criteria. So we have to ensure that we establish clear criteria for assessing risk. We need to ensure that we include the potential impacts, such as the financial, the operational, the reputational likelihood of the occurrence. Critically important. Risk prioritization. Prioritize your risk based on the significance and the urgency. You need to consider factors such as the magnitude of the potential impact, the likelihood of the occurrence, the strategic importance, as well as the interdependencies with other risks. Next, briefly, risk correlation and dependencies. We need to analyze a correlation and dependencies between different risks. Now, some of these risks may be correlated or have cascading effects. So we need to be cognizant of that, which amplifies the overall risk exposure. Next slide. Response planning. Now, out of all the categories on the 5 components of risk management, this arguably is probably one of the more important ones. All of them play critical factors, but this is very important. So let's talk a little bit about risk mitigation strategies. So we have to ensure that we develop proactive measures to reduce the likelihood or impact of identified risk. And these strategies, it may include risk avoidance, it may include risk reduction, may include risk transfer, or risk acceptance. So we need to ensure that we tailor mitigation measures to the specific characteristics and root causes of every single risk. Next, we're going to talk a little bit about resource allocation. So we allocate resources effectively to support risk response activities. And this ensures that there's adequate resources, including, or the most important piece, the financial element, which we know that's the hardest thing to come around to, human element, and technological resources. We need to ensure that they're available to implement risk mitigation and contingency plans in a timely manner. Now, responsibility assignment. We can delegate accountability, but we cannot delegate responsibility. So we have to clearly define roles and responsibilities for executing risk response plans. We need to assign these tasks accordingly to ensure that there is proper accountability to individuals or teams that are responsible for implementing specific mitigation measures or contingency plans and actions. And lastly, ensure that everyone understands exactly what their roles and responsibilities are throughout the entire process from start to finish. Communications and coordination. We need to ensure that we establish clear channels of communication and coordination among stakeholders that are involved in risk response efforts. Obviously, communication is key in any project or any scenario or within any organization, and there is no such thing as over communicating. That's internally to the team or externally to residents or customers. We need to ensure that we are flexible and adaptable, because even though we have a written plan and a process in place today, one thing that is for sure and two things are for certain, that plan will change. For one reason or another, there's going to have to be some adjustments made, and you're going to have to pivot at some point in the future and revise plans. That's why we have scheduled revisions of plans and processes, as well as policies, to ensure that we are codifying not only our risks that we have today, but what we can anticipate happening in the future with certain things changing, that whether it be in our control or out of our control. Testing and exercises. Once we have a plan, we have to exercise the plan. Now, it's highly recommended that you do this from a multi-pronged facet. You do this from a perspective of internal only with your team, but then also you have coordination and collaboration with external agencies. These external agencies, it might be your local police department, it might be your local fire department, it might be your local emergency management department. Just make sure that you have adequate collaboration, communication, and cooperation from any stakeholder group that's going to help you with your business continuity plan or your emergency response or emergency management plans. Next, continuous monitoring and evaluation. We need to ensure that we implement mechanisms for ongoing monitoring and evaluation of risk response activities. Monitor key risk indicators, monitor performance metrics, feedback mechanisms to assess the effectiveness of response measures and identify opportunities for improvement, and make sure that everyone has an opportunity to convey their sentiments and their thoughts in regards to that process. And then last but not least, as you can see here on the slide, documentation and more documentation. We need to document our response plans. We need to document the decisions that were made, why the decision was made, what contributed to that decision, and how you're going to go about making sure that those decisions are evaluated and followed up on for review in the future. We need to have comprehensive records kept on file, whether it be for legal reasons, which I know Tony loves that, or just for reasons to see if we can better our processes sometime in the future and actually identify what processes change and for what reason. Next slide. So looking at risk mitigation, and you can see these 5 pillars here, and we're going to quickly go through these, starting with proactive measures. So this may involve addressing root causes, strengthening controls, or even implementing preventive measures to minimize the occurrence of risk events. So you can't talk about risk management without also saying the word proactive. Any and everything that we do from a risk or risk management perspective should be proactive so we can address problems before they become a crisis. Risk prioritization. We need to allocate resources and our attention to addressing high priority risks that pose the greatest threat to organizational objectives or have the potential for the most severe consequences. Cost benefit analysis. We need to consider the costs associated with implementing mitigation measures against the potential benefits in terms of risk reduction or avoidance. Next, we need to optimize resource allocation by focusing on mitigation measures that provide the greatest risk reduction value relative to their cost. So conducting that cost benefit analysis is crucial to ensure that we are doing any and everything in our power to not only be effective, but also be efficient throughout the entire process. Next, risk transfer and sharing. So the transfer of risks to parties that are better equipped to manage or absorb them, that isn't a weakness or you raising the white flag. That's you doing the best thing for the organization. One great example I can give to you about what risk transfer and risk sharing is, if you have a third-party vendor that conducts preventive maintenance for your boilers. Now, do you have personnel on site that might be able to do some PM with your boilers? Sure. But we understand how challenging it is with high turnover. We understand that one person may have 2 or 3 different roles that they're currently executing. And so using that third-party vendor to conduct your preventive maintenance is the right thing to do if you can afford to do it. That is an example of risk transfer or risk sharing. Last but not least, monitoring and review. So we need to regularly assess the status of implemented controls. We need to monitor key risk indicators. We need to evaluate the residual risk levels to ensure that mitigation efforts remain effective and adaptive to changing circumstances. We need to adjust mitigation strategies as needed based on emerging risk, lessons learned, or changes in the risk landscape itself. Next slide. Risk monitoring. So with risk monitoring, you can see here 5 more pillars. Key risk indicators. Obviously, you want to ensure that you are monitoring your KRIs, and basically what that is an early warning signal or changes in risk exposure of the emergence of new risks. So that could be from a quantitative perspective or from incidents that are actually occurring. So your key risk indicators could be quantitative or qualitative in nature. Thresholds and triggers. Of course, we need to establish thresholds or triggers for key risk indicators to signal when we need to either assign someone to mitigate that risk or have a sit down with stakeholders and create process to drive the impact of that risk down. Continuous monitoring. Doesn't matter if it is an emerging risk or something that has happened already, it's documented. We need to ensure that we are constantly monitoring, whether it be someone assigned with that specific duty or it's incorporated in our regular business processes and practices. Next, integration with performance management. Obviously, risk management, risk monitoring, risk analysis, all of that impacts our performance as an organization. And if we're not doing a good job of it, it can be very problematic and be detrimental to not only our mission, vision, and values, but to the health of the organization overall. And last but not least, risk reporting and communication. Everyone should feel comfortable enough with reporting a risk within the organization without any fear of retaliation or adverse consequences. And so the more that we talk about how productive it is for the organization, for every single member of the team to feel comfortable in sharing not only their thoughts, their ideas, but concerns, and we get through those thoughts, ideas, and concerns collectively as a group and as a team, and it makes the team better because of it. The more we do that, the more we cultivate that into our everyday culture, the healthier we're going to be as an organization. And that makes the job of our risk managers and risk directors that much more easier because we're able to get in front of problems before they are a crisis. And that concludes my presentation on risk management strategies that you can implement and utilize within your team to help keep your organization as safe as it can possibly be. And next, we're going to hear from Pat to talk about the claims process from reporting to resolution. Pat?
Thank you, Reggie. It was a very tough act to follow. So, my name is Pat Triano, Director of Claims here at HAI Group, and just wanted to talk in general terms of what happens from when a claim inception to a claim resolution. And really, even before a claim is reported to us, there are things that you can do when a claim occurs. Obviously, if someone is injured on your property and you know about it, you want to offer first aid. If you're able to secure any evidence, if you're able to obtain any photographs, if you're able to identify any witnesses to the accident, those are all things that are going to greatly help us conduct our initial investigation. And with reporting, we prefer that you do report directly to us, as opposed to, I mean, there's many times when our insureds will have a good relationship with someone in underwriting or someone in account services, and the claim gets reported to them and ultimately sent to us. But if someone is out on vacation or out on extended leave, there may be delay in reporting. So the best thing to do is always to report directly to the claims department. There's obviously the statistics that claims that are reported earlier generally will settle for less, because when people are contacted initially, they'll feel that they're cared about, their interests are being looked at, and we are able to establish a rapport with the plaintiff earlier on. So a lot of times that prevents them from seeking counsel, which, as we all know, when attorneys are involved in cases, they're generally more expensive to settle. So as far as the claim process itself, you may note that the reporting in a previous screen, actually, you'll notice that the the reporting number for claims after hours is 800-873-0242, and then you just press the designated number for claims. We have 24-hour claims reporting after hours. We have an answering service that will triage your call and will contact the appropriate claims examiner that is on duty, and that person would contact you or reach out to whoever needs to be getting back to you very timely if you need a call back right then and there. If you're looking for advice as to how to proceed or how to protect your property from further damage, if it was a property loss. So that's what happens with after hours reporting. But you'll note also, as far as the email address, it has changed from claims reporting at housingcenter.com to claims reporting at haigroup.com. That is our new domain. Both will work. So if you sent something to housingcenter.com, it's still going to get to us in claims. But just make note that the new domain is claims reporting at haigroup.com. That's the best way to report claims to us. It doesn't get lost in between departments. It doesn't get sent to anyone else in error. And that's the most timely and efficient way to do it. It gets sent into our queue, and a number of us will see those claims immediately. Next slide, please. So as far as the process itself, our team is comprised of, we're in the process of interviewing, so we will shortly have 25 claims professionals on our team. And when a claim is first reported, it'll be triaged to see if it's a property claim or if it's a liability claim. Process starts out in the same way, but then diverges into each line of business, how it's actually handled. So a claim initially is reported, it gets triaged, and it gets set up as a claim. A policy, we will determine that there is in fact a valid an active policy in place, and that'll get assigned to a claims examiner at that point in time to look at coverage and do an analysis, and note you'll be given an acknowledgement that we received your claim, and coverage will be verified. If there are any issues with coverage at all, either on our property side or on the liability side, you'll be provided with what's known as a reservation of rights. Some of you may have already received them on previous claims that you may have had, but essentially every insurance carrier, including us, has certain known rights under the policy, included but not limited to the right to deny coverage or to reserve our rights to deny coverage in the future if something is not covered. So that really, you have your policy, which tells you what is covered, and then with the reservation of rights, we will condense the scope of coverage to let you know if it's a property case, for example, and it appears from what was reported that a large portion of the loss was as a result of wear and tear, corrosion, rot, rust, anything like that. That's a maintenance issue. We will reserve our rights. We won't just deny it immediately. We will reserve our rights, send out an adjuster to conduct an investigation on the premises, meet with you, survey the property, look at all the damages that would have occurred, and then make a determination from there. And the same thing on the liability side. If there was an allegation of intentional acts, the insured did something intentionally to me, that's obviously one of the exclusions on the policy. So we would look at that and just notify you that, yes, we are providing coverage to you, and yes, we are going to assign an adjuster, perhaps even an attorney, but we are going to notify you that there may or may not be an issue of coverage on the policy. So you're aware of that up front. From there, we will conduct a thorough investigation. If it is and we always have a national network of independent adjusters that will go out and investigate claims and report back to us as to their findings, whether it's a liability claim. They will determine if other experts are necessary, such as accident reconstructionists. If it's a serious claim, we may want to also retain a crisis management consultant. And as you know, you have $15,000 worth of free coverage to you to do that, to get ahead of anything bad that the press may be, looking for any type of commentary from you. But we would retain a crisis management expert or an engineering expert, was an origin experts, depending on what we would need for that particular type of case. Just as an example, there was one fire we had a couple of years ago with multiple fatalities. And the insurer notified us that there was records that were requested from ATF and the local fire marshal's office. And they were producing all those documents to release directly to those entities. And the director of maintenance was on national television giving commentary. Those type of things we do not want to happen. Everything should be done through counsel. So you never release anything directly because we want everything to be released that should happen through counsel because some things may be subject to privilege and we're not going to release them voluntarily. And the crisis management consultant would also speak with the media and present you and your claim in the best possible light to counteract what anyone else may be saying in the media at the same time. Next slide, please. So for property, we have our local adjusters who will go out and conduct an investigation. They usually can determine the cause of loss, but many times we may need an engineering survey done at the same time. We may need a cause and origin expert to determine the origin of the loss and then the cause of the loss to see if there's any possible subrogation issues, whereas we can settle a claim and then pursue a negligent third party, such as a roofing contractor that may be putting a membrane roof on your building with a torch and they set fire to your roof and cause several tens of thousands of dollars worth of damage, and we will go after them for recovery. After we get the recovery from them and settle with their carrier, their insurance carrier, we would then rebate you, not rebate, but refund you your prorated share of your deductible. So it's in everyone's interest to recognize that early up front, retain the proper experts. And one point also would be with respect to securing evidence. So any evidence that you may have that is not otherwise being held by the fire department, because any fire scene is actually a crime scene. We can't get in there and investigate a claim until it's released by the fire department. But once it's done so, if they haven't already taken things off of the premises, we would want you to work with us to identify anything that may be subject to a subrogation claim, such as a defective stove or any type of defective product, or anything that would give rise to a subrogation claim. We want you to have limited access to that. So if you locked it up initially, make sure that it's in a secure place, make sure that there's only a certain number of people that have keys and access to that, and keep a record of who goes in and who goes out at all times with that also, so that the chain of custody is very well documented. So on the property side, we will send out an adjuster who will survey the damages, take photographs, diagrams, measurements, write an estimate of the damages and send that to you so that you can use that as a guide when you are looking to select your own local contractor to effect your repairs. One thing to note that is we do not mandate that you use any contractors at all. We don't have a list. We don't say you have to use this contractor or that contractor. It's completely up to you. Anyone that you like to use, anyone you used in the past and have a good relationship with, you can use. The only thing that we do ask is that it's a company or an individual that is both licensed and qualified to effect the repairs. From there, we will obtain an agreed price with your contractor, issue a proof of loss, and settle the claim with you directly. That's assuming everything goes nice and smoothly. That's the way that it's handled. There are times with large losses that we also will give you in advance, so you can start working to secure the property, start doing mitigation, whether it's a Surf Pro or a Service Master type of a vendor who's going to come in and extract water from your building, or if it's boarding up the building, or if it's putting up signs to keep out, or if it's putting up fencing around here to keep kids out. Those are all things that you can do with the advances. Next slide, please. So on the liability side, the process is still the same as far as setting up a claim, assigning it to the appropriate adjuster, looking at coverage, determining if there's a reservation of rights that needs to be issued. And then our examiner will assign an adjuster to come out and conduct an investigation. They will meet with you. They will look at if it was a sidewalk or if it was something that happened inside a building or wherever it happened, parking lot. They'll again do photographs, diagrams, witness statements, locate witnesses, and put their report together, send it to us so that we can begin to determine liability. And we would like to prefer to work directly with any claimants before they become plaintiffs. But sometimes that just doesn't happen. You don't know of a loss until down the road. Sometimes first notice of claim happens to be a lawsuit or an attorney's letter. And we just work with that anyway. But if we need to retain an engineering firm to look at a staircase to determine if in fact it was defective, or look at codes, or determine if it was something that was grandfathered in, is it defective? Is it not defective? Did you have reasonable time? Did you know about the defect? Was it debris on the staircase? How long was it there? Did you know about it? Did you have reasonable time to remedy the situation? Did you have a duty to the plaintiff in the first place? Were they a trespasser? Were they a leasee of the leaser of the premises? So we look into all different statuses also, and a lot of times there's even trespassers that come on your property. But what we want to focus on is the fact that under the policy also, we have the right and duty to either settle or defend claims on your behalf, whatever it is in your best interest. We do not just settle claims for the sake of settling claims if they're defensible. On larger claims, we will bring counsel in early on so that the investigation conducted by the adjusting company is subject to privilege. And we also have the right and duty to select counsel when cases go into suit. So under the policy essentially, the insuring agreement says that we shall have the right and duty. But if we issue a reservation of rights, there are instances in which you may have the right to select counsel. In some jurisdictions, just because we issue a reservation, you may have the right to select counsel. In other jurisdictions, just because we issue a reservation, that does not give you the right to select counsel. But if there is a genuine conflict of interest for whatever reason, or something that can give rise to a conflict, then you would have a right to select counsel. And then there's other jurisdictions, Connecticut, for example, policyholders do not have the right to select counsel whether we issue a reservation of rights or not. But we do use national adjusters throughout the country. And we also use national trial counsel throughout the country also. We have smaller firms, local firms that are used. And then we also have larger firms with 1,000 or more attorneys, depending on the type of the case. If we always believe here, our philosophy is that we want the right firm for the right case and the right attorney for the right case, so that we get you the right defense and make sure that your interests are very properly protected. From the defense of the case, again, if it's something that we believe we find that something took place or failed to take place that caused injury to a third party, we will develop the case. We'll get all medicals or medical reports, medical bills, and try to settle the case either directly with a claimant or with their attorney. Many times, and majority of times, we are able to do that in an expeditious manner, but there are times when cases do look like they're going to be settled at mediation or perhaps even settled at trial. But we don't have a reputation of just settling for the sake of settling cases. We don't want to become a target carrier or have our members be target defendants. So we do very vigorously defend cases to their ultimate conclusion if necessary. Is there another slide, or is that it for me? Thank you.
Pat, a quick question before we move on. that came during the property section. If a local municipality, say like the building inspector, what have you, calls for drawings from an architect, like, is that covered as part of the claims process, or do the insureds have to foot the bill for any of those things initially?
Well, that is covered. Architects and engineers are covered. Sometimes it will be covered under extra expense. Sometimes it's covered as a direct expense. If you have a building that is looks like it's in there's a risk of it collapsing because it was struck by a vehicle, we would always want to make sure before anybody goes in there that the building is sound. So retaining an engineer to a structural engineer to do that would be covered. If you had to retain an architect for any type of drawings, specifications, that is also covered. Every now and then we also come across older buildings that that's even more prevalent, and when you really can't restore them to their pre-loss condition, but you want to bring in an architect so that we can make it as best as possible during the restoration.
Thanks, Pat. Take it away, Tony.
Thank you, Pat. Thank you, Andrew. So we've heard a lot of good information this afternoon so far. Reggie's told us the nuts and bolts of how to avoid claims, how to avoid risk, how to manage risk, how to shift it elsewhere. And you can do everything Reggie says, and sometimes you still get a claim. And it winds up with Pat's elite team. And Pat's elite team can do everything they're supposed to do to manage a claim and get it resolved. And sometimes you still wind up with a lawsuit because the claimant just can't be satisfied. And so we get to litigation. That's the third part of our section this afternoon. We're going to give you a rundown on litigation trends that affect claim management, things that we look at. This discussion concerns mostly liability claims. Those are the cases that generally get to court. Sometimes property claims get there, but that's a different scenario. That's a dispute between you and the insurer, and we've got a process to manage that we've been pretty successful with, that gets things resolved and keeps us copacetic and out of court with our insureds. But the litigation trends that we're going to talk about are third-party claims, tort claims, discrimination claims, class actions, things of that nature. These are the claims that take a little longer to get resolved. They can be a little messy. And we're going to get into some of what we're looking at these days that's driving up the cost of these claims and affecting all of us. So just to set the scenario, we're going to talk about things like nuclear verdicts, the rising cost of defending cases and settling them and paying verdicts, a phenomenon called third-party litigation funding. Spoliation of evidence is a sideshow that comes up from time to time. We'll get into that a little bit. The relativity of the awards that come down in these cases, and how the plaintiff's bar has been working to drive things up. So just to set the scenario a little bit, much of this discussion talks about the cost of defending cases and resolving them. A lot of what Pat's group does is they manage the claim process, and they'll settle claims early and expeditiously when they can. A lot of what they do is get nuisance claims resolved. Nuisance claims are things that, can be resolved early on. We might not want to pay on them, but it's efficient to do that. Pat, could you give us, your definition of what a nuisance claim is and how that's handled?
A nuisance claim is a case in which there is little to no liability whatsoever on the part of the insured. The damages are non-existent to low value. And it's a case that rather than incurring significant costs, tens of thousands of dollars in defending a case, for a plaintiff that just won't go away, sometimes we will settle those cases for perhaps $7,500, $10,000, probably no more than $15,000 would be the threshold for saying that it's a nuisance value case. But it's always in the best interest of the insured to try to settle those cases rather than incur several thousands of dollars and have that go against an insured's experience.
And what would you say a typical nuisance case, you know, a slip and fall at a residential property? What kind of a value would you target these days to resolve one of those? And I know it's a very broad generalization, but
Sure.
if you had to peg a number, where would that be?
Well, it would depend on if there were injuries and what type of injuries there were, and the extent of the medical bills, and the extent of the treatment, and the extent of the pain and suffering involved in the case, and the extent of liability. If we find no liability, many times you like to deny those cases, but we also know there's a risk of them going into suit. So looking at the bills, looking at the medicals, and evaluating that. Nowadays, it's higher than you would think when you say nuisance value. If you're going to spend up to $15,000, that's you think, well, is that really nuisance if you're paying that kind of money? But the way that verdicts have been trending nowadays and settlements have been trending nowadays, in today's numbers, 15,000 would probably be as high as I would say a nuisance value claim would be. But it could be anywhere from 5 to 10 to 15.
Thank you, Pat. If you go back in time to when you were a young claim adjuster, what would that same nuisance claim cost you to resolve?
That same claim years ago would probably be in the $2,500 to $5,000 range.
Okay,
Certainly no more than 7,500 max.
okay. So like everything else, over time, it costs more money to get things done.
Absolutely.
Okay, so that's one end of the spectrum. At the other end of the spectrum, we've got nuclear verdicts. We've got things that cost ridiculous amounts of money to resolve. Next slide, please. So we've all heard the phrase nuclear verdicts. As Reggie mentioned early on, these are the larger claims. The defense bar, the DRI, and other organizations that align with the insurance industry typically consider cases that resolve at 10 million or more to be a nuclear verdict. There's been surveys done, and as you can see, the Chamber of Commerce has been looking at these things. And as Reggie mentioned early on, between 2010 and 2019, the median nuclear verdict rose from 19.3 million in 2010 to 24.6 million in 2019. Again, over time, everything costs more. That's the nature of handling claims. That's the cost associated with claims. You know, we can talk about what inflation is. That's somewhat quantifiable and measurable. And we all look at indexes from time to time. The other factor that affects liability claims is social inflation, the perceived value of money. And the phenomenon is such that a trend of larger claims generates more larger claims. We can't easily predict what does that. We can see where it happens. There are certain jurisdictions that are known for returning those outsized verdicts. There are things that happen over time in society that tend to drive those things. I think we can look at COVID as one of those things that's probably prompted a more recent rise in large verdicts and large claims. People got used to seeing certain things funded that weren't funded before. And so their perception of money associated with various things in life kind of got skewed. And there's some statistics on that. There's another organization that looks at nuclear verdicts, the jurisdictions that return them. It's the American Tort Reform Association. Again, another organization that's lined up with the defense bar and with insurance companies. And each year they put out a study, a report that looks at the large verdicts across the country, and they rank each state to come up with the winner, if you will, the number one nuclear jurisdiction in the country, and it ranks down from there. Traditionally, we always thought of California as being somewhat out there and somewhat dangerous. In more recent years, that's kind of shifted. In the 22-23 report, Georgia came out on top. Georgia came out on top because over the 10 years before that, they returned something on the order of 50 or more nuclear verdicts worth about $3 billion. And the cap of it all, the one that really drove them over the top to number one, was a $1.7 billion punitive damage verdict against Ford in 2022. It was a product liability claim. It was framed around a Super Duty truck and the claim that the roof of the Super Duty truck was too weak. And there was a rollover accident, as you might imagine, and a couple of folks died. And in itself, that's a claim that's worth money. The value associated with death in a product scenario or death in almost any other scenario can be calculated with some degree of relativity. We know what the economics are associated with loss of a life of a breadwinner. We can look at things like pain and suffering and make some general judgments about that. And over time, we've seen enough cases that we can come up with some ranges of what a case might be worth. We've seen verdicts, and history is a good indicator of where these things go, or it has been. So this particular case, what blew this one out of the water, the $1.7 billion, was for punitive damages. And the punitive damages came out in a very unusual way. A punitive damage award usually punishes the defendant as a wrongdoer for having done something really outrageous, and something that caused this claim to arise that should never have happened, and something that was clearly avoidable. You look at things like, could this accident have been avoided had they, invested in a $5 part for each of the F-150s that they produced over the last several years? Somebody makes a decision, no, we're not going to do that. Those are the kind of things that aggravate the value of a case, because one would believe that, and rationally so, if you could make a car safer by investing $5 against what may be a $50,000 truck, it would be reasonable for the manufacturer to do that. And a jury hearing that the manufacturer didn't do that, and that failure is what caused this particular accident and this particular injury, would rightly believe that there should be some measure of punishment. That wasn't the case here. That wasn't the reason for the punishment here. The reason for the punishment here truly turns into litigation abuse. There are a few instances of litigation abuse in this particular case, and the punitive damage award was pretty much dictated by the judge in the way he issued trial rulings that more or less funneled the jury into a particular outcome. You can Google the case. It's well known. It's well reported. But just a few things to highlight it for you and show you what the problems were and what helped put Georgia on top as the #1 judicial hellhole in this particular report from the American Tort Reform Association. Plaintiff's lawyer brought this case in Cobb County initially, wasn't happy with the way the case was going. It wasn't moving along fast enough for his tastes. He got some initial rulings that weren't to his liking. What did he do? Something that you really can't get away with in many jurisdictions. He voluntarily dismissed it in Cobb County and started over again in Gwinnett County within his statute of limitations. Forum shopping. You'll hear a bit more about that this afternoon. But forum shopping, that's been going on forever. Plaintiffs will pick a venue that's friendly to their case, where they perceive their chance of an outcome would be greater than had they brought the case in a more appropriate form. For example, Georgia, we know, is a judicial hellhole, generally speaking. In this particular instance, this one lawyer believed that a particular venue within Georgia was better than another. Sometimes it gets more extreme. Sometimes you'll find plaintiffs bringing cases in a state where a defendant might have operations when in fact the circumstances that bring about the claim happen in a different state. And the lawyer who he retains is from yet another state. But because of the venue and jurisdiction rules, he's able to bring that lawsuit in a jurisdiction that the plaintiff's lawyer believes is more friendly to the case, and that probably has a history of returning outsized verdicts. That's forum shopping. So this particular attorney forum shopped from one county in Georgia to another, winds up with a judge who's got a reputation for being somewhat aligned with the plaintiff's bar, who had practiced plaintiff's personal injury litigation for a period of time before becoming a judge. And then it goes downhill from there for the defense. There are some preliminary rulings issued by the judge. Georgia has traditionally followed a rule that seatbelt evidence is not allowed in to show the culpability of a driver or a passenger in an accident. Some jurisdictions follow that rule. So the judge issues a gag order on that. The judge also issues a gag order on an autopsy. What's interesting about that? In and of itself, you would think that the autopsy evidence should be admitted in a wrongful death case. You would think that a plaintiff would want the autopsy evidence admitted to show that his decedent clients suffered a gruesome death, drive up the value of the case. You would think that the plaintiff would want the autopsy evidence admitted to show that the accident happened through no fault of his clients. They were unwitting victims in some fashion. They would use that autopsy evidence to feed into an accident reconstruction, a biomechanical reconstruction, and so forth. Why was that evidence not admitted here? There were some interesting circumstances. The autopsy was done in the new jurisdiction, and it was done ex parte. Don't ask me how they got away with that, but somehow the coroner exhumed the bodies without notifying any of the other parties, made his examinations, came up with a report, and interred the bodies in a way that they could not be studied again. Very unusual circumstance. So during the course of this trial, case could not be settled, it goes to trial. Defense counsel is trying to get in all kinds of information that the judge was trying to preclude. The vehicle for that are what we call motions in limine, pretrial motions that would either confirm that evidence could be admitted or preclude it from being admitted. Judge wasn't happy with the way defense counsel was trying to work around adverse rulings on those motions. So he issued a sanction establishing all elements of the plaintiff's liability claim. And it was downhill from there. The case went to verdict. There was essentially no way for it to defend liability. It was purely on damages. And because the judge determined that there would be a sanction, this outsized nuclear $1.7 billion sanction was returned, was appealed, and stay tuned for the rest of the story. We'll get back to you on how that turned out. Apologies about that. So that's what puts Georgia up on top in the judicial hellhole survey. And it's gotten worse since then. Premises liability cases in Georgia have been going bonkers. The plaintiff's bar has been very effective at nullifying the jury to real issues of liability, so that we're seeing adverse outcomes on premises liability cases where the property owner really has no responsibility. There was a very well-publicized case involving CVS and a shooting that happened in their parking lot involving two individuals, neither of whom set foot into the store. CVS was somehow found responsible for that accident. The theory being they should have had more security in the parking lot. Apologies, I don't know why people are trying to get through to me when they shouldn't be able to get through to me. Number 2 on the list is Pennsylvania. They've got a similar history of returning outsized verdicts. In Pennsylvania, the exposure to the outsized verdicts has typically come about in medical malpractice and product liability cases. It's creeping into premises cases now. It's a jurisdiction where, with respect to HAI Group and our member insureds, very frequently we have a favorable rule, if you will, that caps verdicts against housing authorities at $250,000. Is that correct, Pat?
Yes, it is. 250 per person or $1 million per car.
And in some instances lately, the courts have not been respecting that. So Pennsylvania is creeping up on the hellhole list for a number of reasons, somewhat similar to Georgia. And if anybody's interested in seeing that report, it's available online. The other phenomenon that we're seeing that's driving the cost of third-party claims up is third-party litigation funding. Next slide, please. I'm sorry. Back up. We'll get there shortly. Third-party litigation funding is what it says it is. We've got folks that come in and offer money to plaintiffs' attorneys to carry the costs of a case, so they can invest in experts, so they can provide some money to their clients before verdict. But it's a loan. It has to be repaid at the end of the day. And sometimes the interest is outrageous. So what happens? The plaintiff's attorneys are now, their tolerance for risk has been elevated, if you will. Rather than settling a case that could have been settled at the early stages for a reasonable sum that might have some relation to the medical expenses incurred, to what might make sense for a pain and suffering component, they're now emboldened because they've got money to carry a case. They're not looking to resolve it quickly. They're not looking to turn that case over, get it done for their client, move on to the next one. They're going to take this case as far as they can and leverage it as much as they can, because they know that statistically, if they can get a case into court, they're going to do better. And when they do this in a jurisdiction like Georgia, like Pennsylvania, it's that much better. So what they're doing is they're taking advantage of claimants. They're causing plaintiffs' attorneys to make decisions that aren't necessarily aligned with their client's interests. They're taking more risk with a case, and they're betting that, and many times it does work in their favor, a case will settle, and it'll settle for more money because they're going all the way into court rather than resolving it at a moment in time where it could have been resolved for a sum that was reasonable to do. So they're turning the court system into a business. They are increasing the likelihood that a case is going to go to trial. They're driving up defense costs on top of driving up indemnity costs. There's been some surveys about how much money has been invested into this, and it's been in the billions. In 2022, Wellfleet Advisors reports that the third-party litigation funding business put about $13 billion into the tort system. So it's really beyond control in many respects. There are some reform efforts underway. Some states are enacting disclosure requirements so that the defendants, when they ask for information relative to the claim, are now also able to ask whether a case is being funded by a third party. What does that do? That helps us understand, well, this case could go down that road for reasons unrelated to the claim. And maybe we can get creative and find ways to tag the plaintiff with that in the process before it gets to trial, embarrass them with that at a deposition, maybe make them less likely to want to go to court because we know the game that they're on to. They know we're on to the game. And they know there could be an outcome they weren't bargaining for. Maybe we'll get creative enough that it comes out in court. Maybe we can start treating that like a collateral source. These efforts are kind of early. We're not quite there yet. But third-party litigation funding is a subject that you're going to hear more and more about. It's probably the thing that's driving up litigation costs more than anything else today. Next slide, please. One more. We mentioned early on how well coordinated the plaintiff's bar is, and you've probably heard the phrase reptile theory. Reptile theory, it's what the slide says. It attempts to use the fear factor to draw out the jury's emotion, to make them dislike the defendant, so they'll award excessive amounts of money. And it plays on, it's called reptile theory because it plays on the reptile part of your brain. That's the sexy phrase they associated with this. A reptile reacts to protect itself. The reptile doesn't necessarily want to eat a human being, but it feels threatened, so out it lashes. And so they're playing on that part of the brain that protects. And this is a big business within the plaintiff's bar. They put on seminars about the reptile theory and how to use it. It's a form of argument that really violates a rule. There's something in litigation practice known as the golden rule. A golden rule argument is where an attorney asks the jury to place themselves in the shoes of the victim. It's usually a damages argument and usually runs along the lines of, you know, if this were you, how much would you think it's worth to deal with that pain every day for the rest of your life? Is it worth $10 a day? Is it worth $100 a day? Reggie's shaking his head. He says those are rookie numbers. And that's what they do. They put you in the shoes, you the juror, in the shoes of the victim, and it's wrong. There's a rule against that. But the reptile theory has been used to skillfully skirt that golden rule. And to do it in a way that really ups the ante, because it's not necessarily going at damages. It'll get there, but it goes at duty. It gets back to that $5 part question. You know, it's encouraging the jury to favor personal safety and the protection of themselves, their family, their community, over what might be common sense. And I'm not saying it's not common sense to favor safety and protection, but the arguments they're using is they're appealing to the jury's emotions. They're turning them from a neutral fact finder into an ally, and it's got dangerous consequences. Jurors are invited to disregard their oath, to go outside the evidence, and to tap into their emotions. The first thing a judge tells you as a juror is you're to decide the case based on what you see and hear in this courtroom, not on anything else. And they say it all the time, sympathy shouldn't play a part in your deliberations. We know everybody's got sympathies, but everybody's entitled to a fair case. And the reptile theory works its way around that. It taps into emotions. So, you know, there's many examples of how this has played out. You know, there are typically cases that involve a premises. There are typically cases where a property owner has, let's say, a third party on the property. Let's say you as the property owner have somebody at the property doing some work and they're up on a scaffold, something falls and injures a passerby. You've got no control over that. But you as the property owner are probably a more attractive target to sue than the contractor who's working on the scaffold. So you get sued. There's generally no basis to sue the property owner for vicarious liability with respect to that contractor. The property owner generally doesn't control what that contractor does. It's an independent contractor. The property owner doesn't tell the contractor when to start and stop, which hammer to use, how to swing it, how to set up safety, and what protocols to use on the job. Those are all decisions that the contractor makes. The contractor's in control of all that. And so in ordinary cases, in most cases, when that happens, when that hammer falls from the scaffold, property owner is not responsible for it. The contractor is.
Tony, just a reminder, we are at 2:34 here.
Okay, we'll wrap it up real quick then. So reptile theory works around that. Reptile theory is they start talking about safety, they start talking about how somebody can't be made safe enough, and it would have been very easy for the property owner to do something to avoid this. Anyway, that's what we're up against. We're up against reptile theory. We're up against a very well-organized plaintiff's bar. We're up against jurisdictions where, you know, nuclear verdicts are becoming more and more common. Anyway, I apologize for taking a little too much time. We're at the end of our session. We hope you gained some insights into the risk management process, into the claim management process, and into the things that we deal with defending claims that get into court, defending lawsuits. We may have a little time for question and answer. Andrew, that's entirely up to you.
We don't have any questions right now, but we just have some comments, and there's one comment from Margarita saying reptile theory sounds like a scam, and I think you'd probably agree with that. But no further questions from here. So Reggie, if you want to take us out.
Thank you so much, Andrew, and thank you for that great presentation, Tony. And wow, it's only Thursday, right? I wish we could end the week on this note, but we have to come in bright and early. I'll see everyone in the office at 7 a.m. sharp as we close out the week and get ready for a great Monday for next week. So great discussion today. I started off the afternoon by talking about the 5 components of risk management. Those 5 components is risk identification, risk analysis, response planning, risk mitigation, and then last but not least, of course, risk monitoring. So very technical discussion. There's so much more that we could have gotten into. But again, if you have questions or if you'd like to further that conversation, please email me, give me a call, and I'd love to speak with you about it. So after my presentation, we transition over to Pat, our Director of Claims, with his presentation that was titled The Claim Process from Reporting to Resolution. We understand, for you all as our members, we understand that when it's time to file a claim, it could be very stressful, very challenging. But rest assured, we are here to help and to be of assistance. So please know that we take great pride in being responsive. We take great pride in being available, and it's not just business for us. We look forward to interacting with you, with conversing with you, and to help solve your issues and make your challenges as easy as possible to mitigate. So please reach out to us without any hesitation if we can answer any questions that you may have. We also talked about the claim process as it varies depending on whether it is a property or a liability claim. So how we go about executing those claims are going to differ depending on if it's property or if it's liability. So after Pat's presentation, we transitioned over to Tony with his presentation that was titled Litigation Trends Affecting Claims Management. So we heard and learned a lot about nuclear verdicts, the rising litigation costs, plaintiffs bar collaboration. So now litigation is now a business. So it sounds, and reptile theory. Who would have thought? And then last but not least, with Tony's presentation, we discussed median verdict for nuclear claims has risen from $19.3 million in 2010 all the way up to $24.6 million in 2019. So we can only anticipate that number increasing as years go on. And so we want to thank you, myself, Tony, and Pat, on behalf of all of us at HAI Group. We want to thank you for your time, your attention, your participation today. Just know that you will receive the session recordings and resources via email very shortly. We also, HAI, we will have a booth and a large presence at the National Narrow Conference, and please stop in and say hello if you're going to be attending. I know from a risk perspective, our director, Beth Owens, I believe she's going to be there. And our loss prevention fund application deadline is May 31st, 2024. So if you have a need, please apply and have a chance to get a piece of that $2 million pie. We look forward to reading and going over your applications and hopefully helping you accomplish your goals. And then last but not least, our virtual risk conference is going to be November 7th. We had great participation last year with over 400 attendees. And rest assured, this year is going to be just as exciting and just as captivating. So again, On behalf of Pat and Tony, we thank you for your participation. This would not have been possible without our great marketing team. So thank you so very much. Amy, Tyler, and Andrew, you all are phenomenal. And we wish you all a great day, and we hope that you have a wonderful weekend. Take care, be safe.